This is Barry Zalma on insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to talk about the challenges faced by insurers when they use in-house counsel to defend their insureds. Defense counsel are sometimes employees of an insurance company. Some attorneys have challenged the use of in-house counsel on the ground that the insurer, as an employer of attorneys, is not licensed to practice law. They claim that the insurer was engaged in the unauthorized practice of law, a crime. Attorneys in Texas convinced a trial court on the issue, but the decision was reversed on appeal. Attorneys have also raised challenges against house counsel because the employee attorney is alleged to be serving two different masters. As an employee of the insurer, it is alleged, the attorney cannot do justice to both his client, the insured, and his employer, the insurer. A Texas Court of Appeal refused to limit the right of insurers to hire staff attorneys in a case called American Home Assurance Company versus Unauthorized Practice of Law Committee, where the court stated, quote, American Home and Travelers may use staff attorneys to defend claims against insureds, provided that the insurers and the insured's interest in the situation are congruent, as described in this opinion. But staff attorneys must disclose their affiliation to their clients. Another Texas court concurred and said, quote, use of staff attorneys to represent insureds is not the unauthorized practice of law. As Utilities Insurance Company versus Montgomery, a 1940 case from the Texas Supreme Court, pointed out, the insurance company is providing an attorney to the insured who is seeking to protect its own interests. Even though the attorney does represent the insured, the insurance company is not practicing law because of the company's direct financial interest in the litigation against the insured. There is no violation of the Texas Business Corporation Act because the purpose of an insurance company is to indemnify its insureds. The agreement to defend and pay attorney's fees is collateral to that purpose. 6 of the state court decisions cited Utilities Insurance Company versus Montgomery as supporting the majority rule, even though Montgomery involved the use of outside counsel. Even Gardner versus North Carolina State Bar, which held the use of staff attorneys constitutes the unauthorized practice of law, pointed out that Texas has a special rule for insurance companies and cited Montgomery. In Cincinnati Insurance Company versus Wills, a 1999 case, found that the precise question was whether an insurance company engaged in the unauthorized practice of law when it employed house counsel to represent insureds. Specifically, the plaintiff in the Wills case sought to disqualify the defendant's insurer from using house counsel, arguing that it amounted to the unauthorized practice of law. The court held first that the use of house counsel to represent insureds did not necessarily amount to the unauthorized practice of law, and second, that in-house attorneys appearing as counsel to defend claims against an insured did not necessarily trigger an impermissible conflict in violation of the rules of professional conduct. In reaching this holding, the court made several observations about the notice required to a policyholder regarding the possibility that house counsel may be used for claims defense. Evidence presented to the court that contended that State Farm either one, delivered a product different than that promised in the policy, which stated clearly that it would provide counsel of its choice in the event of a lawsuit, or two, was unjustly enriched by its house counsel arrangements. As the Indiana Supreme Court noted in Wills, that statement that, quote, in the realm of insurance defense, the public may ultimately reap the benefits of better service at lower cost through the use of house counsel, close quote. This hardly sounds like the makings of a claim for unjust enrichment. The reasonable market value of the attorney's services is the measure of a reasonable hourly rate. This standard applies regardless of whether the attorneys claiming fees charge nothing for their services, charge it below market or discounted rates, represent the client on a straight contingent fee basis, or are in-house counsel. The California Supreme Court in PLCM versus Drexler affirmed the trial court's award of prevailing market rates to a corporation represented by salaried in-house counsel. The court explained, quote, the fee-setting inquiry in California ordinarily begins with the lodestar, that is, the number of hours reasonably expended multiplied by the reasonable hourly rate. California courts have consistently held that a computation of time spent on a case and the reasonable value of that time is fundamental to a determination of the appropriate attorney's fee award. The reasonable hourly rate is that prevailing in the community for similar work, even if the attorneys are working for a salary for an insurance company. The defense attorney should be required to report to the claims person and to the insured defendant on a regular basis, and the adjuster should establish reporting requirements clearly with the attorney. Reporting requirements should include, at a minimum, whether the attorney is house counsel, salaried employee of the insurer, or an independent lawyer. 1. That the attorney report the progress of the case no less than 60 days to the claims person and the insured, even if the report states nothing new has occurred. 2. The copies of all pleadings filed by both the attorney and his or her opponent must be delivered to the adjuster and the insured. 3. That the attorney need send only one copy of each pleading to the adjuster and the insured, regardless of the number he or she may receive. And 4. That with regard to answers to form or pattern interrogatories, requests for admission, requests for production of documents or other written discovery, and minor pleadings such as demands for jury trial or notices of continuance, the attorney should use his or her discretion as to whether to advise of their existence, summarize, or to send copies to the adjuster and the insured. If the case is complicated or has multiple parties, the adjuster may wish to keep only a skeleton file of pleadings and discovery and obtain summaries of relevant pleadings and discovery from the attorney. Now that technology permits it, the attorney should be asked to avoid excessive use of paper documents and instead send copies of the documents, pleadings, discovery, and correspondence in an electronic form like an Adobe PDF that any person can read. In every litigation where defense counsel is involved, whether as house counsel or as an independent lawyer, at the moment the suit is assigned for defense, The adjuster and the defense attorney must have a clear understanding of the adjuster's involvement in the preparation of the case for trial. The adjuster must make it absolutely clear that the attorney is required to abide by any guidelines provided by the insurer. If the attorney believes the guidelines impinge on his or her ethical obligations, he or she will advise the adjuster, and they should then work together to modify the guidelines appropriately. The insurer's guideline for case control and billing may change from time to time. The adjuster must keep abreast of such changes made by the insurer's management and promptly inform the attorney of the changes. Control of the litigation process rests with the insurer, who pays the fees or the salary of defense counsel, as long as they do not deter the lawyer from representing the insured, who has been hired to represent the insured as his or her client, not as a client of the insurance company, as required by his Code of Professional Responsibility. The insurer retains and pays the attorney to represent the insured defendant. The attorney is obligated to serve his or her clients, the insurer and the insured defendants, as they desire, as long as their instructions do not cause him or her to breach his or her professional ethics. The insurer must accept the fact that it retained defense counsel to do everything necessary to properly defend the person or persons insured. If instructions from the insurer ask the attorney to breach his or her obligation to the insured, counsel must so advise the adjuster, and if the insurer insists, a competent, ethical, and honorable lawyer will resign rather than breach the ethical requirements of the profession. No adjuster, no insurer should ever put their lawyer assigned to defend an insured, whether house counsel or independent, in a situation where that lawyer must ethically resign from the case. So despite the adjuster's prerogative to direct the attorney's handling of the case, the prudent adjuster will not prevent the defense attorney from doing work the attorney advises is necessary to properly defend the insured. The adjuster and the attorney must meet regularly to review the file and discuss the need for further investigation, further discovery, and any changes in the evaluation of the exposure the insured faces that have resulted from the work done by the attorney since the last meeting. The case review meeting should take place no less than once every 6 months and more frequently as the case comes closer to trial. The insured should be invited to attend and participate if the insured is able. In addition to allowing the adjuster to become totally familiar with the case, the periodic case review sessions allow the adjuster, the attorney, and the insured to get to know each other on a personal basis. This will allow the 2 or 3 to foster a mutual relationship of trust and respect that cannot be achieved with contact only by telephone, letter, email, or fax. After each case review, the adjuster and counsel should agree on the terms and conditions of a report to the insured and insurer concerning the status of the case as discussed at the case review meeting and whether the insurer needs to modify its reserves. In the last 3 months before trial, these meetings should take place as often as needed, including weekly conferences in the last days before trial. It may be necessary for the adjuster and the attorney to meet as often as daily to properly prepare for trial. This video was adapted from my book, Zelma on Insurance Claims, Part 108, Second Edition, which is available from Amazon.com as both a Kindle book and as a paperback, and is one of the 10-volume set, details about which are available at my website, zalma.com, by clicking on the link to the insurance claims library, which will describe all 10 volumes and all other books published by me and written by me. Please, if you found this video to be useful to you, convey it or forward it to your colleagues. It's free. And also, please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can be advised of future videos and future blog postings. Thank you for your attention.